The other thing that I found really helpful is, especially if you're in a regulated industry like trucking, there is so much you can get from public information requests or Freedom of Information Act requests. Just on trucking, there's information on all the inspections they've had, any weather crashes they've had, what violations, when they've been warned about violations. Sometimes even, they get audited for a compliance review and they get a safety rating. And so it's like satisfactory is the best rating, which means they're good enough. Conditional is like you've got some real problems, we're not going to put you out of business. And unsatisfactory is you cannot operate anymore unless you convince us you've changed. Well, a lot of times you'll see satisfactory as the rating, but then to get the satisfactory, you'll find that the government noted all these problems in their inspection, but because they promised to fix those problems, they went ahead and left them as satisfactory. And, a lot of times you find that those same violations happen in your case. Mm-hmm. And so now we don't just have a case where someone broke the rules. We have a case where someone got caught breaking the rules. They were told, hey, you're breaking the rules. You have to stop doing this. They promised, and to stay in business, they promised we will do this from now on. This is our plan. And then when the government inspector went away, they went back to breaking the rules. Yeah. I think that's a much better case.
Yeah. And I think, if you've been following along with the podcast, that sounds a lot like gross negligence to me.
Yeah, exactly.
So, so you can get other kinds of causes of action when you do that. And broken promises are just some of the most upsetting things to anybody, jurors included.
Yeah, it really takes out of what that defensive attribution, which is one thing the defendants think is one, this wouldn't have happened to me because I wouldn't have put myself in a situation the plaintiff had. But then there's also the fear, I don't know, maybe it's not defensive attribution, but it's like, I would hate to be sued and lose everything because I made a mistake. And there's this fear that if this could happen to somebody else, it could happen to me. And I don't want to live in a world where I'm doing my very best. And unbeknownst to me, I make some little bitty mistake that I didn't even realize I made. And now I lose everything. And I think that's a very real and realistic fear because of people misconstruing, most good verdicts are not based on someone making a little mistake. And so I think the more you can show that it was a choice and that they had knowledge that this is important, this is unsafe, people can get hurt, that you promised not to do this, and then you do it anyway. Not just the broken promise, but the knowledge that what I'm doing is wrong makes the jury want to say, okay, now this person is different than me. They knew something was wrong, and they did it anyway. They don't care. And now we got to do something about this because these kind of people in the world are a threat to me and my family.
So
I'm in a reptile mood today, if you can't tell. Yeah.
So there's actually a lot of other industries where companies need to make promises to stay in business. It's not just trucking. So this can apply to your workplace safety case. So people make promises to OSHA if they've had OSHA violations before and settlements and things like that. Or people make promises if they're a restaurant or something like that. And it's a slip and fall case. They're making promises about the safety of the premises to whoever they're leasing the building from. So there's promises in places that you might not expect.
Yeah, our health code violations, they may have noticed water on the floor or leaking ice machines or other things. Bars, if they've had people get caught for over-serving or serving underage drinkers before, which you often have, you find that history of violations through we just resolved a dram shop case, and that's one of the things that was helpful was finding that this particular entity had broken the rules before and they'd been caught, and then it happened again. So just showing that knowledge that, hey, you do have a problem with your employees. Whatever training you say you did, it ain't working because the Alcoholic Beverage Commission's been in here and they've caught them breaking the rules and fined them, and now it's happening again. It's much less of a it's so unfair to us. We spent all these years building up this business, and one employee does something wrong. How do we control what every little person does? I think it just the more we're fair, the more likely we are to win.
Yeah. And so you should be looking for broken promises or just any promises in every single case that involves a company, because a company exists generally to make money and have customers of some kind. So there's some promise they're making somewhere down the line to someone about something.
Right.
Now, it might not be related to your case, but you should be trying to pull at that thread to figure out who are they making representations to out in the public in order to have their business operate effectively. Is it to customers? Is it to the landlord? Is it to government agencies? And you got to pull at that thread and see, is there a promise that I can use in my case that they broke?